Well, welcome back to the Williams Elleby Howard Easter YouTube channel. I'm Joel and this is Mark, and today we're going to go through a pre-trial process over a recent $7.2 million medical malpractice verdict that we got down in Dougherty County, Georgia for a very deserving client of ours. And we're just going to kind of break this whole thing up into two different sections. And even though we are generally personal injury lawyers, we're based out of Kennesaw, we practice all over the state of Georgia. And so this particular case happens to be one that was filed and pending and tried down in Albany, Georgia, which is kind of that southwest corner of the state. But for this video, part one, we want to go through the pretrial process from step one all the way up until when we walked in the courthouse steps, just so you can see the background of what all goes into a medical malpractice case and how complicated it can be. And it may give you some insight into why attorneys tend to be very particular and specific about the kinds of medical malpractice cases that we take, because there's a lot of risk involved, and we'll go through that as well. But Mark actually had this case referred to him by a different lawyer down in the central part of the state, and that happens a lot. We get cases from other lawyers that call and ask us to become involved with them. We get cases from people that watch YouTube videos. We get cases from people that find our website or however. They can come in from many different ways. But Mark, why don't you tell us, let's rewind all the way back to when you first got the call on this case and tell us how that happened.
Sure, and even before we did this video, I went back and looked, and when was I originally contacted about the case, which was September of 2022. Mm-hmm. We just finished it now in February of 2025, so that's how long it took.
Which is actually fairly quick for a medical malpractice case with as many witnesses and experts as
exactly. It is actually pretty quick, which most people don't like to hear, but these cases take a while. But in this particular case, the family had questions about how our client's husband had died at a hospital, and they had gone to a private coroner down in southwest Georgia who had done an autopsy. And the coroner found some things that bothered them, and so they reached out to a lawyer in the central part of the state who then contacted us, and we met with the client. And in this case, it was what's called a wrongful death case, and because the person who died was married at the time, Georgia law allows what's called the surviving spouse to bring the claim. Even though she has the right to bring the claim, they had children together, so those folks at the end of the case also have an interest in the recovery. But she's the one who had the right to bring the lawsuit. So we met with her, we talked to her, and looked at the autopsy, and then got the medical record. That's step one.
Mm-hmm. Yep. So step one is just getting the documentation that you need to help you determine whether or not there's even a case that could potentially be brought, or whether it's worth bringing that case, or if there's too much risk involved. So once the medical records come in, we know what the autopsy says. Basically, we know what the cause of death was, at least according to the medical examiner. Then we get those records in. What happened after we got the records in?
Yeah, so typically it's a multi-step process, because these cases are so time-consuming, so expensive, and so complicated. You really have to do a deep dive into the medical records. And there's some cases we get where I look at a case and I think, wow, this is a pretty clear-cut case. That's rare, but it's very clear-cut. There's some cases where right away you're like, no way, no how, we're never going to win this case. But there's some where you just don't know. And what I like to do is, after I look at the medical records, is I'll then take the next step and go to the medical literature. And what that really means is, when doctors go to medical school, they have textbooks, they have journals that they review, and now, of course, there's a million online databases that, and you have to sift through a lot of garbage, but there's some that are very, very reliable. And in this case, we used a database called UpToDate, which is widely used in hospitals around the country, and it suggested to me, anyway, that we had a case. So the next step after that is to get an expert to look at it. And that's what we did. So we hired an expert who then confirmed what we thought about the medical literature. His opinions were exactly what the medical literature said. And he was willing to then sign on to the case, which in Georgia you have to have an expert for a medical malpractice case. And he signed a sworn affidavit saying that he thought there was malpractice, and that's what got us going.
Yep. And so what Marc means by having to have an expert, what he's essentially saying is that in order to file a lawsuit for any professional malpractice, and this one it happens to be medical malpractice, but it could be legal malpractice, accounting malpractice, nursing malpractice, all kinds of professional malpractice cases, you have to have an expert in that area to sign an affidavit. You have to attach it to the complaint or to the lawsuit in order for your lawsuit to be viable. If you don't have an expert to support it, then the court will throw your case out right out of the gate, and you'll be dead in the water before you get started. But backing up one step, the basic facts of this case were a gentleman from Southwest Georgia was having nausea, vomiting, diarrhea for 3 days. It got to a point to where he was feeling terrible. He called the ambulance. They took him to the hospital. He was brought to the emergency room. He went to the emergency room. The doctor did an abdominal exam on him because he was having some abdominal tightness and tenderness and pain. They ran some tests. Didn't know what was wrong with him. He failed what we call a PO challenge. Some people call it a swallow test, but it's basically where you take a sip of water, and if you keep it down, you pass it. If you can't keep it down and it comes back up, and you fail that PO challenge. When he failed the PO challenge, the emergency room doctor decided to admit him to the hospital. He saw a hospitalist about 4 hours after he got to the hospital. When the hospitalist saw him, he ordered a routine CT scan and then took some extra history about the patient and all that kind of stuff. The CT scan was done right before midnight at 5:50 something in the morning. The CT scan results came back showing that he had a large mass in his lesser sac, which is kind of below your left rib cage, as well as some free-flowing blood in his abdomen. Unfortunately, the patient had already died in the hospital prior to the CT scan results coming back. At 2 a.m., 3 to 4 hours before the results came back, he coded. They brought him back 3 times, but he had lost so much blood through his internal bleeding that his heart just could not sustain a rhythm, and he passed away at 3:15 a.m. So circling back to the ER, our allegations in the case were that the ER doctor, even though he ran certain tests, should have ordered a CT scan there, which we alleged would have shown the internal bleeding for the patient. Then an interventional radiologist, a general surgeon, a vascular surgeon, somebody that could have addressed the bleed to stop it, could have been called, brought in to control it while the medical providers figured out what the long-term solution for this problem would have been. And then we also found out throughout the course of discovery, which we'll get into in just a minute, that on average, if the CT scan had been ordered stat in the ER, then the results would have been back within 2 hours, which would have given them plenty of time to intervene and save his life. In this case, the hospitalist was also a defendant because we alleged that the hospitalist should have ordered the CT scan stat. And so as we're working to prove the case against these doctors, that we file the lawsuit with the expert affidavit, then we enter into what we call the discovery period. And there's a lot, to say the least, that goes on during the discovery period of a medical malpractice lawsuit. So you want to get us started with that, Marc?
Sure. So first of all, you just have to gather basic facts from each other. You send written questions to each other, requests for documents that go back and forth, trying to make sure you have everything. And then you have to sit and think about, what do we need to prove our case? We need to take depositions or sworn statements from the doctors. We may need to take sworn statements from hospital officials about how quickly could you have gotten a surgeon here, how quickly, how available were blood products, how available were operating rooms, those kind of things. But there's also what's called expert discovery. And this is one of the big challenging parts of a medical malpractice case. Is first, we had to think about what experts do we need.
Yep.
And we had the coroner who had done the autopsy, so he knew about the cause of death, and he was the one who found the internal bleeding. But we also had our ER hospitalist expert who said that there was malpractice. But we also thought, hey, we need a general surgeon expert to talk about what's called causation. Did the malpractice actually, could it have been prevented? Did the malpractice cause the death?
Yeah, and that's a good point, because even if the doctor made a mistake and the the care fell below what we call the standard of care, which would be malpractice. If that mistake didn't cause the death, or if the patient would have died anyway, even if the doctor hadn't committed malpractice, then you lose. So you have to cover negligence as well as causation of whatever the injuries are. But
yeah, and our hospitalist ER expert, even though he could say there was malpractice, he wasn't qualified to say whether a surgeon could have saved him. Mm-hmm. So in this case, we got a general surgeon from Duke University to come in and testify on our behalf. Yeah. And then the defense, of course, also is entitled to name their experts. And in this case, boy, did they name their experts. We had our two experts who we hired, but we also, there was the coroner who, he was a fact witness. We didn't hire him, but he had opinions to give. The defense named 8 experts that they paid to come in, plus they were relying on the 2 defendants themselves to give opinions. Mm-hmm. So they had 10 experts, we had 3. Yeah. And
they doubled up on some of them.
Yeah, sometimes they would hire, and this is a typical tactic that the defendants use, is they'll hire 2 different experts in the same specialty, and they'll see how one does in a deposition. They'll hear all the questions that I ask in the deposition, then they'll name another expert, and they'll prepare that person knowing what I might ask. So,
yeah, and in this case they had 2 emergency room doctors as experts and 2 hospitalists as experts. They also had 2 employees that worked for the same physician group. One was a general surgeon, one was an interventional radiologist. They hired a vascular surgeon out of Vanderbilt. Who else?
They hired a pathologist.
A pathologist. Yep.
And they also hired, they had 2 hospitalists, I think you said, and they had the defendants themselves who are allowed to give opinions on standard of care as well.
Yep. And so they lined them up and brought them all in and paid them a ton of money to say that what these doctors did or didn't do was within the standard of care.
And during the discovery phase, that's one of the big times that it becomes time-consuming and expensive. I think for about a month and a half solid, I did nothing but take expert depositions and prepare for expert depositions and travel to expert depositions and then pay the experts for the time they spent sitting for the depositions.
Yeah, and the reason that we have to do all that is because when you name an expert in a case, you have to say, okay, Dr. Howard is a emergency room doctor. We expect him to testify that the Dr. Williams did not comply with the standard of care or did comply with the standard of care. And that's pretty much all you get. And so you have to depose them, take their deposition to find out why they say what they're going to say. What materials are they relying on? What things can you find out that may discredit their testimony to some extent? But generally, you want to know anything and everything that they're going to say at trial so that you can be prepared to address those issues when the trial comes around. And so it's super important to find out, whether it's through oral depositions or there is such a thing as called written depositions. Some attorneys like to go that route. But whatever route the attorney goes, they need to make sure they know everything that the adverse party's expert is going to say at trial so you can be prepared for it. Not only at trial, but also to judge the credibility of it and kind of balance that risk management strategy. Should you settle the case? If you think settlement might be a good idea, how strong are their opinions? Are you worried about them? Because if you're not worried about them, that settlement number may be higher. If they seem like they're very credible and that you can see how a jury could buy into what they're selling, then your settlement number may be lower in that whole risk management analysis.
Yeah, and so that is an amazingly time-consuming process. And Georgia law typically for your average run-of-the-mill case will say, oh, you've got 6 months to do all that. But in a medical malpractice case, that gets extended over and over again. And in this case, we had well over 1.5 years of discovery.
Yeah, one of the biggest headaches that we have as lawyers in cases like this is when you're trying to coordinate your schedule, your opposing counsel's schedule, the professional witness's schedule, all of those things. And sometimes in medical malpractice cases, you're going to have 10 different defendants because it may be a doctor, it may be the hospital, it may be a nurse, it may be a corollary provider like a radiologist or whoever's involved in the care, if they contributed to the malpractice or the mistake that was made that caused the harm, they may be defendants. And so, a lot of times you're going to have 4 or 5 sets of defense attorneys on the case, and then trying to schedule all of that together just becomes an absolute nightmare to get a day that all of these people can be available.
Exactly. It takes forever. And another interesting aspect about this case is we used what's called Rule 30b-6, which is a rule of discovery where you're allowed to actually take the deposition of a corporation.
Yeah.
And in this case, we took the corporate deposition of the hospital, and they had to provide us witnesses and documents to testify about information that was in the corporate knowledge. So we did that in this case, and of course that adds to the time and the effort we have to put into the case. But it's important to lock down all those loose ends before you head into court.
Yeah, and it was especially important in this case because with us alleging that the CT scan should have been ordered and that had it come back, they could have taken interventional measures to save this man's life, we also had to prove that the hospital had these things available to save their life. So, for example, was an interventional radiologist or a general surgeon available? Were blood products available? Were radiologists available or interpretive radiologists available to look at the imaging and say what was going on in the imaging? And turns out we had to use those witnesses to prove that. All those things were available, but we had to prove it because you can't just assume it, right? And then also, as part of the allegations against the ER doctor, our client, the deceased in this case, our client was his widow, but he was 66 years old. He had had 3 prior abdominal surgeries, and those put him at high risk for intra-abdominal bleeding, or at least something serious going on in the abdomen, which would have required that CT scan. And then we had to use the 30b-6 or the corporate representative to say, hey, look, all of these things are available to the ER doctor to utilize, or the hospitalist to utilize, in order to, figure out what's wrong, address the issue, and then utilize the tools available to the doctor to fix it. Right? And then also one more thing. Sorry, this hospital happened to be the same hospital that the deceased in this case had been to several times, and so this medical history was already in the chart. And we found out through the course of discovery and taking depositions and things like that, that the ER doctor had not looked at his medical history, so he wasn't aware of the prior surgical history that this man had, which played into the ultimate outcome of this case. That one thing was a small part of the negligence that happened, but it was a very important thing because the doctor was making these decisions without all the information that was readily available to him, and the corporate representative was the one that could go in and look at the electronic medical record, what we call an audit trail, and determine who in that hospital had looked at this man's medical history, and it turns out that the ER doctor did not. So
yeah, and these audit trails are really important evidence for cases like this, because now with electronic medical records, anytime anyone does anything, it has to be entered in a system, and there's a electronic fingerprints of that person on the record. And we get these things, sometimes they're tens of thousands of pages long in these crazy Excel spreadsheets that are hard to read, but you just got to comb through those things and see, did someone actually do what they said they were going to do?
That's right. So all of that stuff's involved in the discovery process. There's other things that are important, maybe not quite so important, like written questions we send to the other side where they have to answer things under oath. We request documents and things from the other side that we may not have already. They do the same thing for us. They also deposed the widow in this case and asked her some questions about her husband's life, some of his comorbidities and things like that. They also, a little closer to trial, deposed his daughters to ask them some questions. But we get through this discovery process that's very time intensive and takes a lot of effort on the doctor's part, on the lawyer's part, as well as the witness's part to get ready for and complete. But once discovery was over, then we participated in what we call a mediation. And a mediation is a formal settlement conference where two parties come together and they hire a neutral, usually an older lawyer, exactly what we did in this case, who's not actively practicing law every day like maybe he or she was when they were our age, but they now just try to broker deals and help parties come to a resolution in the case. So we both hired a mediator to try to get the case resolved. That did not work out. Can't go too much into what happened at the mediation because everything that happens at a mediation as far as numbers and stuff are confidential. But needless to say, we were not able to reach an agreement at mediation. And so at that point, we knew, hey, it's time to start buckling down and getting ready for trial. So we hired someone to help us do what we call a focus group. And a focus group is where you get somebody to gather 12 people from the community where you're going to try the case, sometimes not, but in this case we got 12 random people from the county where we tried the case, and we presented an abbreviated version of the facts to them, our best arguments, the defense's best arguments, and got feedback from them on what they thought was important, because sometimes as lawyers you get so far into the weeds that you don't see the big picture, or you only see the big picture and there's some minor detail that you don't think is important, but 12 people who don't know much about the case think is extremely important. So we did the focus group. We got some valuable feedback from them that helped us refine our arguments for trial. And then also some valuable feedback from them on what the defense may present that was persuasive to them. So we knew what our weakest arguments were from 12 strangers' perspective, as well as what our strongest arguments were. And we held on to that and kept that in mind the whole time as we made final preparations for trial.
Yeah, and those focus groups, you can't underestimate the value of those because, like Joel said, you may be thinking one thing the entire case, and as soon as you present it to some people who are disinterested, they come up with their collective wisdom of a whole different perspective of the case. And it certainly helps us, and we can talk about it in the next video about the trial, how we incorporated that. But I think it's, for any case of this magnitude, you've got to do a focus group.
Yep. And so behind the scenes, I'd say, because the way it works normally when you hire a plaintiff's firm to represent you in any case, that firm is going to advance the expenses that are the cost associated with bringing your case. So it's very risky for the law firm, because most of the time if the case is lost, then the law firm loses all that money. They lose all the time that they put into the case. So at this point we are tons of hours of work into this case, as well as we were probably, I'd say we'd advanced around $50,000 or $60,000 in expenses, maybe a little more by that point. But the expenses by this point have started adding up, right? Now we know, hey, we're going to trial. It gets really expensive around that time. And so once we know we're going to trial, there's a lot of motions that are filed by both sides with the court to try to narrow the issues for trial, to try to determine what evidence is going to come in, that kind of thing. And there's also what we call a pretrial order. So as far as the motions go, they're called motions in limine. So do you want to talk a little bit about those, Marc?
A motion in limine is a fancy way of saying a motion to exclude evidence from the case. And one of the big steps before a trial is after you've done all your discovery and you think, wow, okay, now it's time to take a little break. No, then you have to deal with the motions. And I must have spent at least a month before trial doing nothing but either writing motions or responding to motions, and then going out and arguing those motions. And they could be anything from trying to keep out a personal embarrassing fact about someone out of trial. It could be trying to keep out some irrelevant evidence. In Georgia, you're not even allowed to talk about things like insurance, and so it's to keep out that. It's to keep out evidence that people think is just too inflammatory to come into the courthouse, even if it might have relevance. And it's up to the judge to determine that. And so we just had to have those battles, and then the judge makes a ruling. Once the judge makes a ruling, we kind of have the evidentiary playing field, or at least you think you do, and you know which evidence is likely to come in and which evidence is likely to be kicked out.
Yeah, and that's why, I mean, there's always going to be some objections that happen during trial, but it's much less frequent nowadays than it was maybe 50 years ago, because for the most part, if everybody follows the rules like they're supposed to, you pretty much know what evidence is going to be admissible and what evidence is going to be excluded before you walk into the courthouse. The other document we were talking about is called the Consolidated Pretrial Order. The pretrial order is where we list what lawyers are going to try the case, who the potential jurors will be qualified to, meaning do they have any relationship or have any knowledge of certain people in the case that have a financial interest in the case. Both sides kind of type out their abbreviated version of the facts of what's going to happen. You have to list the legal issues that are going to be tried in the case and any applicable law that applies to those legal issues. You have to list all the witnesses that you could possibly call. You have to list every document you could possibly call. Both sides have to do that. Any stipulations of fact that everybody agrees, hey, this is a fact, we're not fighting over this, that's got to be listed in there. Then we also have to say things like the possibilities of settling this case are great, average, poor, non-existent, all that kind of stuff, and submit a proposed verdict form for the court's consideration. And then, so we submit our portion, the defense submits their portion, we try to consolidate all that stuff together, then we present it to the court. We have what we call a pretrial hearing, and we go to the courthouse, we sit there with the judge, and the judge goes through the pretrial order with us, and then may make some changes or alterations to it. And then ultimately, before the trial, they'll sign off on that pretrial order and enter it into the record. And then that pretrial order supersedes any other pleadings that have been filed in the case. So basically, this one document, which could be, 20 to 80 pages long, just depending on how many things are involved in the case, gets filed, and then that's sort of the playbook for the trial, and the lawyers have to operate within the rulings of that pretrial order before we walk into the courtroom.
Yeah, and I always get a little stressed out doing the pretrial order because you've done all this work, you've thought about all these issues, and if you make a mistake and don't include something in that pretrial order, and then you need to introduce that piece of evidence or that issue or that witness, and it's not in the pretrial order, you're out of luck. Yeah. And so I always try and just go through it with a fine-tooth comb to make sure, what have I missed? What am I not including here?
Yep. And so at this point, we're about 2 months out from trial, because this trial was what's called a specially set trial, meaning that the judge knew that it was going to take multiple days to try this case. And so he said, hey, we're going to start on February the 10th. Is that what it was?
I think it was, yeah.
Yeah, okay.
Seems
February
like
the 10th, and we're going to go until it's done, right? So at this point, we're about 2.5 months out from the trial starting, and that's when a lot of work happens kind of at the last minute. So,
and a lot of expense.
A lot of expense, because at this point, you're dealing with everything from trying to figure out all the witnesses that you're going to call, because you may have 50 witnesses that know something about the case, but it's not, every one of them is not important enough to call at trial. Otherwise, you put the jury to sleep. So you try to figure out which ones are vital to the case. You have to get them subpoenas issued so that they have a legal document requiring them to show up. You have to arrange for expert witness travels, and that's super tough because you're trying to guess. I mean, some of these experts cost $10,000 a day just to show up at trial, and you're trying to fly them in from other parts of the country and guess what day that they might be testifying. And so you're doing all that and trying not to waste $10,000 a day while the expert just sits in a hotel room somewhere waiting to be called. But while you're doing all of that, you're also preparing for jury selection and opening statement and the direct examinations of your witnesses, the cross-examinations of the other side's witnesses, closing statements, all of these things, legal arguments that you anticipate are going to be made during trial. You're preparing that, but You're also having to work with your staff to get all of your exhibits ready to go. And in a medical malpractice case, there's going to be thousands of pages of exhibits, but mostly the medical record, but then also other things as well. And then you're going to have to sit down and prepare your witnesses, not tell them what to say, but just prepare them for the experience of testifying in front of a judge and in front of a jury, and knowing how that's not like it is on TV, right? You're going to have to help them understand the environment they're in, what kind of questions you anticipate asking, what kind of questions you anticipate your adversary will ask, and make sure that they're comfortable with that process. You're also arranging hotel rooms, and you're arranging travel arrangements for yourself and your staff and all of these type things. You're getting blow-ups made. You're creating PowerPoints. You're doing all of this to get ready for trial. And so there's a ton that goes into getting ready to walk into the courthouse on the first day of trial. And I would say what lawyers do in the time period prior to walking into a courthouse is so much more important than what happens in the courtroom. You have to be a good trial lawyer if you're going to try cases, and you have to understand what you're walking into. But if you don't do the pretrial process right, you can forget it, because you won't have the witnesses prepared, you won't have the documents you need, you won't have a full grasp of the legal issues that are going to be tried. And without all of those things being done and being done well, you got a real tall mountain to climb to win a case at trial.
And we try and do it in such a way that if something happened to me during a trial day, Joel could pick up and take my outline and run with it, and he knows the case like I know the case, and we try and be that prepared. So even if something goes super wrong, someone gets sick, someone gets hurt, or for whatever reason can't be at trial, we're ready.
Yeah, you never know. I mean, I've got 3 kids at home. My wife works too. So what if one of my kids got deathly ill? It's not just me. There's tons of things that could happen, and so you have to have a backup for a backup for a backup anytime you go into getting ready to try a case, especially a lengthy case that's going to last as long as a medical malpractice case does. So. Anything else we need to talk about?
I think we've walked it all the way up to the courthouse steps for this video.
All right. Well, thank you for sticking with us through this pretrial process. In our next video that'll come out next Thursday at 6 p.m. Eastern Standard Time, we will kick those courthouse doors in. We will walk through there, and we will walk you through the trial of this case that resulted in the $7.2 million wrongful death verdict for medical malpractice. Thank you for sticking with us, and we will see you next week. As personal injury lawyers, we love what we do, and we're happy to share the experience we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when you're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.